you for joining everyone, and thank you Juan Carlos for reaching out to NIJC. We are the National Immigrant Justice Center. I'm going to start off with talking about DACA, and then Julian will go into Illinois policy updates. So before that, just some background on our organization. So NIJC does services in which we not only provide legal services for immigrants through also some assistance from pro bono attorneys, but we also do federal litigation, which involves challenging laws, policies, and practices, as well as advocacy at the local and the national level. Next slide, please. Next slide. Oh, thank you. So I'm going to start off with talking about DACA and where it stands. Next slide. So on January 20th of this year, President Biden issued an executive order preserving and fortifying DACA, the Deferred Action for Childhood Arrivals program. So what this order establishes is that it's further instructing the Secretary of Homeland Security and the Attorney General to take the necessary steps to maintain and strengthen the DACA program. So there have been a lot of great changes and propositions that have come about, which Julian will talk about. There's three that are highlighted here at the national level, I believe. And yeah, when it comes to DACA, one of the things that has been proposed is there being a possible pathway to citizenship. At the moment, basically the DACA program has gone back to the way it was under the prior administration, prior to the Trump administration. So the government is now taking applications for people who are applying for DACA for the first time, initial applicants, as well as people who are qualified to renew their DACA. And DACA is valid for 2 years and must be renewed every 2 years. Next slide, please. So we encourage anyone that believes that they might be eligible for DACA to reach out to us or to any other qualified attorney or legal service provider to assess their case. Currently, when it comes to updates for DACA, we're still waiting on a decision from a Texas case that's challenging DACA, but currently there are, once again, applications being taken for initial applications, renewals, as well as something called advanced parole, which I'm going to talk about. So we're going to first talk about initial applications to DACA. Next slide, please. The next one, thank you. So when somebody's applying for DACA, there are some very strict, hard requirements. So the way that they're broken down, there's 4 main sections: age requirements, presence requirements, education requirements, and criminal activity disqualifiers. So I'm going to go into each one of them a bit. So some of the age requirements are to have been born on or after June 16, 1981, to have entered the U.S. prior to turning age 16, and to be at least 15 years old at the age of filing your application for DACA for the first time. When it comes to physical presence requirements, it is required that the person demonstrate evidence of having been physically present in the United States on June 15, 2012 without any lawful status. That is the date that the Obama administration enacted DACA. And then another requirement is to have resided continuously in the US since at least June 15, 2007 to the time of filing your application. Educational requirement is being in school or having graduated high school, obtaining a high school diploma, or being enrolled in a GED course or obtaining your GED. And criminal disqualifiers would be that a person cannot be convicted of a felony, significant misdemeanor, or 3 or more misdemeanors not arising out of the same scheme of misconduct or otherwise pose a threat to national security. Next slide. So when it comes to proving age and identity, what is necessary is something that demonstrates your date of birth as well as valid photo identification. So that can be covered simply with just a passport, because a passport will have your date of birth as well as a photo ID, or with a combination of a birth certificate and a photo ID, any national ID from your country of origin with photo and or fingerprint, a driver's license, or any school issued ID with photo. And then when it comes to demonstrating entry into the United States before turning age 16, I have a small gap in between the first three bullet points and the last two, because the first three, there are some people who enter the United States on visas. So they would be people who would have possibly a passport with an admission stamp or DHS document, DHS meaning the Department of Homeland Security, with an entry date, or a Form I-94, which are arrival records or travel records, tickets demonstrating their arrival into the US. But then when it comes to if somebody came in illegally into the country, other ways of demonstrating entry into the US before turning age 16 could be school transcripts or vaccines or medical records. When it comes to proving physical presence in the US, I will say that DACA is one of those applications that is very document heavy, in that there is a lot of documentation that's required. So the goal is that an applicant wants to get a document with their name and date from June 15, 2007 to the time that they file their application. It's recommended that a document is obtained demonstrating physical presence every 3 to 4 months. And some examples that could be used could be school transcripts, phone bills, utility bills, medical records, bank statements, mortgage records, leases, or loans, docs, for example. And we continue on. I already had talked about this earlier, but yeah, there is the requirement of having completed high school or having obtained a GED, and a person could, provide proof of being currently enrolled in the program, and that is sufficient to satisfy this requirement. Next slide. So now we're going to talk about renewing DACA and what that consists of. So who's eligible to renew? Anyone who met the guidelines that we just went through for applying for DACA for their initial request. And it is important for someone to renew their DACA before it's been a year since it expires. So if it expired less than 1 year, a person can file for a renewal, which is more simple. But if more than a year has passed since the DACA has expired, it is necessary for the person to apply again as an initial applicant, meaning that everything that we just went through, a person would have to submit once again as if they were applying for the first time, because renewal applications are more simple. You don't need to provide all of this documentation anymore, such as proof of high school or proof of physical presence. So yeah, it's very important, of course, to renew it within a proper time frame. Otherwise, going through the whole initial application. Another thing is that it's important for a person to not have departed the U.S. on or after August 15, 2012, unless they exited the country, unless a DACA recipient exited the country with advanced parole, which I'm going to go into a bit in just a moment. And then to have continuously resided in the U.S. since applying for DACA, and of course to not have any issues with the law or criminal history, such as being convicted of a felony, a significant misdemeanor, or 3 or more misdemeanors. Yeah. The cost to apply for DACA and also to renew is $495. That is what the U.S. government charges, USCIS charges. There are some forms of support for people who are applying. For example, the Mexican consulate here in Chicago does provide some assistance and resource for those most in need. And then we also have on this slide some other possible scholarship resources. Of course, there's plenty of stuff out there, so it's a matter of searching, right? Next slide. So when it comes to advanced parole, one of the benefits of DACA, which I've even noticed that some people who I've worked with who are renewing or people who are applying sometimes are not aware, but it's a really great benefit in my opinion, which is that they can apply to have permission to travel outside the US and be able to return lawfully. So generally this is only granted, DACA recipients are only able to apply for advanced parole and be allowed to travel out of the country for 3 reasons. They do have to submit an application. We at NIJC do help applicants with applying for advanced parole. So the first one, humanitarian purposes, that is the most popular one in which we've seen people apply for the most part for advanced parole. So that is if, for example, someone has a sick relative or to attend a funeral, unfortunately, that is considered a humanitarian purpose. The government does require that when applying for advanced parole, that it is demonstrated, there's proof demonstrated, such as medical records, for example. And then the other 2 reasons why somebody could qualify to apply for advanced parole would be for educational purposes, such as study abroad programs, academic research, or for employment purposes, such as your job, having a conference, interviews, trainings, meetings. So something I want to really emphasize is the importance of legal consultations. So that's just very crucial. We do advise to be aware of notary fraud, or in Spanish, notarios. We have had several clients who return, and it's important to go with someone who is qualified to give immigration legal advice, such as a licensed attorney, Department of Justice accredited representative, or law students who are under supervision by an attorney. And before I hand it off to Julian to talk about policy updates, a bit more information on NIJC. Aside from currently helping people with applying for DACA, as well as doing DACA renewals, we also provide assistance for people who are in removal proceedings or deportation proceedings, family-based immigration, which is when someone is trying to fix their immigration status through being petitioned by a relative. And this includes we provide some assistance for people who have to go through a process called consular processing, or applying for certain waivers or forgiveness, as well as protection-based immigration forms of relief, which are the U visa for people who are victims of crime, T visa, trafficking, and VAWA, which stands for the Violence Against Women Act, as well as Special Immigrant Juvenile Status, SIJS, asylum, applying for naturalization or citizenship, renewing your green card, as well as people who are from certain countries that have temporary protected status, or TPS. What we don't do are employment-based immigration petitions, student visas, tourist visas, or non-immigration legal services. All right, so I'm going to pass it over to Julian. And again, as was stated before, if there's any questions on DACA or about anything that Julian mentions, we'll be glad to take questions.
Thank you, Jaime. Good afternoon, everybody. Again, my name is Julian Lazalde. I'm with National Immigrant Justice Center based here in Chicago. My title technically is a civic engagement policy analyst, but essentially that means is that I focus on our policy work as it relates to, for the most part, here at the city level in Chicago, working on policies that are going through City Hall, to a lesser extent at the county level, particularly in Cook County. But the vast majority of my time, certainly over the last couple of years, has been spent in working with allies and other external stakeholders in relationship to, with regard to immigrant-focused legislation and policies at the state level. So that's what I will, for the most part, be focusing on. And then there is also a part of what I do, which is you see here with some of this proposed legislation. This is federal proposed legislation. I, in fact, am the only a Chicago-based policy staffer for NIJC. I have 5 other colleagues on staff, but they're all based in Washington, D.C., working on federal legislation. And so to whatever extent I can support them in their work, I'm asked to do that as well. But they're really the ones leading our efforts on the Hill with members of Congress, particularly on these pieces of legislation, these sort of larger pieces of legislation. But a lot of our work in Washington, D.C., especially over the last 5 or 6 years, has been focused on the issue of funding of appropriations as it relates to immigrant detention, immigration enforcement, and how we can sort of reimagine that and re-envision that as a country. So obviously it's been a tough hill to climb the last couple of years, or for quite a while, frankly, but That said, we're keeping at it. And when it comes to these bills, I'll just kind of go through this somewhat briefly because they are quite large in nature. But the DREAM Act of 2021, some of you may be pretty familiar with that term at this point. Unfortunately, the DREAM Act, I think, is turning 20, if I'm not mistaken, here in 2021. So the first time that it was introduced by, I think then he was our junior senator, and now he's our senior senator here in Illinois, Senator Durbin, he introduced it in 2001. This year's version is the Senate bill number is S264. And essentially it's the same bill that's been reintroduced every single time before. This year it's being co-sponsored by Senator Lindsey Graham. And it's, essentially focused on the population of individuals that are colloquially known as dreamers. So now at this point, adults, young adults, some children likely, but for the most part, slightly older adults at this point, or young adults that were brought as children to this country and were brought as undocumented immigrants themselves. And so this bill, I know that is quite close to Senator Durbin's heart, and he's still trying to push it now that he's the chair of the Senate Judiciary Committee. He's in a better position to do that compared to previous years, because that is the committee in the Senate that this bill has always been assigned to and will continue to be assigned to. At this point, there hasn't really been much movement, at least nothing that we could see from the outside. That said, I'm sure negotiations and discussions are going on, given that we have this bill, Senate Bill 264, but then we also have these other bills. The second one, known as the U.S. Citizenship Act of 2021, the bill number for that is HR 1177, HR 1177. That is, as you see here, President Biden's day one immigration bill that was promised during his campaign, and that was dropped in mid-February. And that's, for lack of a better term, that's essentially what we would call a Christmas tree bill, because it has a lot of provisions that many different stakeholders in this sort of sphere of immigrant rights and immigrant advocacy have been calling for quite a long time. But one of the things that I think is of great note are, dreamers, people with temporary protected status, and immigrant farm workers that would meet specific requirements would be, and as our understanding is that would essentially mean the vast majority of people in those categories would be eligible for green cards immediately. And could apply for citizenship within 3 years if they continue to meet the requirements once they have their green cards. And that's in relation to what's usually a 5-year process. Once you get your green card, you have to wait at least 5 years before you can apply to be for citizenship. So that's a big one. And there's also a provision in there that calls for creating what's known as a lawful prospective immigrant status, LPI. And so that's 6 years in length, and it would be renewable if necessary for all undocumented individuals in the country who arrived in the country before January 1st of this year. So essentially, the vast majority of the estimated 11 million undocumented individuals in the country at this point. And so that's huge. Sure, there's plenty of negotiations going on. Again, with respect to this bill, it's been introduced, right? But these are bills that really take quite a long time and usually get negotiated heavily before they get, let's say, a committee hearing, or a final committee hearing. And the final bill that's listed here is the American Dream and Promise Act, which is the bill number for that is HR 6. And so that bill is one that NIJC has had publicly some issues with, because there is an inclusion of criminal bars in the legislation. So in 1996, just to be very brief, in 1996, there was a bill that was passed and signed by then President Clinton, which essentially created what are known as 3- and 10-year bars for individuals, depending on how long they have been in the country and documented. You would either, if you were attempting to obtain your green card, you would either need to essentially leave the country for a period of 3 years. If you were here, I forget, I apologize how long, but a fairly short amount of time, you'd have to leave the country for at least 3 years or possibly up to 10 years. And so that's been a real sticking point for immigrant rights advocates and impacted community members since then, because it has really done some great harm to members in our community, in the immigrant community at large. And so that is also included, as a matter of fact, in the President Biden's bill, the U.S. Citizenship Act of 2021, the removal of those 3 and 10-year bars. But as you see here, we have different pieces of legislation that kind of hit on the same communities. And so essentially what we hope for and expect is that at some point there will be what we think is going to happen is there will likely be some sort of version, an amalgam of these, probably through the U.S. Citizenship Act. But there's a lot of, what we understand is that there's a lot of negotiation going on right now to figure out what, if anything, can be done to essentially get around this sort of 50-50 split that we see. In fact, I think even just yesterday, right, we saw that in the Senate on any major legislation. And so we understand there's a lot of negotiation going on regarding how to pass some sort of larger immigration reform. I hesitate, frankly, to say comprehensive immigration reform, because I know that that's kind of become a sticking point, that term, for a lot of folks, but a larger, essentially omnibus immigration reform bill that would be suitable for the vast majority of immigrant rights advocates, particularly, but then also more importantly for the impacted community members. But we are looking for is something that could possibly be passed through the reconciliation process. That's another term I think a lot of us are just getting kind of caught up to speed on, compared to, let's say, a decade ago, where I feel like I didn't hear it as much. But now there is a process to try to get, certain bills that are perhaps bigger and a little more, a little touchier for some folks, that would not need 60 votes, as the case is right now in the Senate, and therefore is the reason why a lot of legislation really has not passed or even been considered. And so if there could be sort of a bill or legislation crafted in a way that would meet the budget reconciliation process requirements, then you would just need 50 votes, or 51, excuse me, to pass anything in the Senate. And I think that's what our understanding is, that that's where our senators are trying to sort of focus efforts right now. That would essentially be sort of an inclusion of pieces of all of these 3 pieces of legislation in particular. And there is one other piece of legislation that I want to touch on that is not listed here, which is known as the New Way Forward Act. So that is HR 536. And the New Way Forward Act is a piece of legislation that was sponsored by Congressman Chuy Garcia. And that is also a larger piece of legislation that we think may have a chance, but we're looking to try to pass that in the coming year as well. And so moving forward, apologies, I know that was a lot. I really want to touch on some, I know I just kind of walked through a lot of things and there's a lot of ifs and buts. So I'm really pleased to speak about what happened in Illinois during this legislative session, because it's already happened, and it's all these bills I'm going to talk about have been passed at this point. So the first one is the Illinois Way Forward Act. So that is essentially sort of modeled on the previous bill I just mentioned at the federal level. It's a way to strengthen, hopefully, the ties between immigrant community members and the wider community as a whole. And one of the things that we really focused on, based on community member feedback, is this first point, which is phasing out of these contracts, these intergovernmental service agreement contracts between counties in Illinois and ICE to detain immigrants. So right now there are 3 different counties across the state of Illinois that have such contracts. The first is in McHenry County, the other is Kankakee County, and then the final one is Pulaski County, which is in far southern Illinois, to the southern tip of the state. And so each of those counties have a contract with ICE right now to detain immigrants. In most cases, those immigrants are unrepresented, so don't have legal representation either from an organization such as ours or private representation. And we're really excited because this bill is going to essentially phase out those contracts. So it's requiring these contracts to no longer requiring these counties, to no longer have these contracts with ICE as of January 1st of next year. So I want to be clear, that's not to say that there will not be any, there will likely still be detained adult immigrants in detention here in Illinois starting on January 1st, but the process essentially will need to begin the phasing out of those contracts. So we expect that if all goes according to our hopes, that by the spring of next year, essentially there will be no detained adults in any county jail or any jail in the state of Illinois that are awaiting processing by ICE. So That's a huge victory because that's already been coupled with a bill that passed 2 years ago, which prohibits for-profit detention by private companies, which is a really equally insidious thing that has really grown and expanded across the country. So private companies detaining immigrants in private jails, in particularly. And so that's no longer going to be the case here in the state of Illinois as of January 1st. So we're very excited for that. And there's a lot of work to be done to make sure that people just aren't transferred to a different out-of-state detention center, but hopefully are released back to their homes and to their communities while they await the adjudication of their immigration cases. Because in many cases, that's exactly what's happening. These folks were picked up in almost most every single case on very minimal grounds, most of them being traffic stops, and then are subsequently detained. And so we really want to make sure that that does not continue to happen here in the state of Illinois. And with this bill, we're much closer to making that happen. Next slide, please. So I'm going to start with the second one, which is House Bill 369. So this is a little more specific to NIJC, given what we do, which is legal service the biggest chunk of what we do as an organization being legal service representation. So this bill is going to allow vulnerable immigrant youth that, as of right now, only are allowed up to the age of 18 to seek what is known here as what's called a predicate order, an SIJS predicate order. That is essentially something you have to get from a state court here in the state of Illinois, but it only allows up to the age of for people up to the age of 18. However, federal guidelines allow individuals up to the age of 21 to obtain an SIJS predicate order. So this is essentially bringing us up to on the same level with the federal regulations, and is really going to be a positive impact because in many cases, not every vulnerable immigrant youth is 5, 6, or 7 years old or a child. I mean, a 17-year-old is a child as well, an 18-year-old is a child. But in many cases, we represent youth that are 16, 17 in some cases, and these cases can take a long time, can take years. And so that this way, no one will age out essentially from being able to obtain an SIJS predicate order in the state of Illinois. And we're really excited about that as well. And a couple of this expungement bill is also something that's really exciting because it's, again, focusing on that sort of interplay between criminalized communities across the state of Illinois, which is something that's all too well known in communities of color. But this bill, Senate Bill 2136, allows immigrants that are no longer in custody to seek what is known as relief from a previous conviction based on an immigration issue that are, years after the fact. So sometimes, someone who is an immigrant maybe was picked up for another issue, pled guilty or on advice from an attorney without understanding what the potential ramifications are for their immigration case, right? Because immigration cases and criminal justice cases are two separate things. So this is going to allow for individuals to be able to seek some redress through this process. And we're really excited for that as well. And again, our attorneys, particularly on staff at NIJC, are super excited about it, which makes me very happy. And so these are some of the bills that, we have been working on for quite a long time. And we're very excited to have them passed. And the final one I would like to mention, it's not listed here, is House Bill 2790, which is not a bill that we worked on, but I want to give a shout out because I know CRLN, is a part of some of the same networks as like the Resurrection Project and Westside Justice Center. But this allows for the Public Defender's Office here in Cook County to represent immigrants in immigration court here in Illinois. There's only one immigration court here in Chicago, but as of right now, public defenders are not allowed to do that. And so now this is going to open the door for that to be the case. And we expect that it'll likely be for people who are detained, but there may be a possibility for immigrants who aren't detained, but have a case before an immigration court. So really huge. And the doors are starting to open, we hope, for people to be able to be represented by more individuals in immigration court, because that's really the biggest hurdle to getting your immigration case settled and you hopefully on a path to citizenship is having legal representation. So I think, let's see, maybe I should stop there. And I feel like I see a couple questions are coming in. So maybe should I just try to address that? I see a question from Linda. Why has comprehensive immigration reform?
Sure, I can read them off for you.
Okay.
Just give me a second.
Sure.
Okay. First question. Why is well? Thank you for first of all. Before we get into the questions, thank you, Julian and Jaime. I do have a question myself. For Jaime, but in just a second. Let's get into the questions. We have a couple questions here from Linda Eastwood, and to everyone, please do list your questions in the chat. Write them up, and I'll get to them. First one, why has comprehensive immigration reform become such a hot button term? What are the objections?
Yeah. Thank you, Linda. As I understand it, I'm not trying to speak for the immigrant right advocate community as a whole, but my understanding is that just comprehensive immigration reform has been, as a term, has been used for so long. I mean, essentially going back to the days of, particularly of the DREAM Act, as I'd mentioned, 20 years ago. And often it's been used, I think, by a lot of different politicians at different levels of government, so not just the federal level, to, I think in the eyes of a lot of folks, basically make grand promises that have not been kept, right? Especially in moments where there have been maybe some bigger openings to obtain, to reach some form of immigration legislation, which would provide a path to citizenship for undocumented immigrants. And so I think it's become a term that some folks are perhaps just kind of tired of, frankly, of using, and kind of attach a lot of promises that haven't been kept, in many cases, because you have such bills like this Biden bill, the Day One bill, and as the more I have done this sort of work, the more I understand that there's, sometimes you may throw out all these sort of provisions in a bill, and then a lot of them get negotiated away at the end, and then maybe in many cases it still doesn't pass, so it's been, I think, the continued promise, but the inability to get to that final goal of immigration reform that I think has left kind of a sour taste in people's mouths overall. But again, I'm not trying to speak for the entire immigrant community, certainly not, but that's what I've heard a lot. And frankly, at different points, I felt that myself, to be quite honest. Yeah.
Okay, I do have another. Well, there was the push for the Dream and Promise Act, which would help cover and bring in people with TPS status and Dreamers, DACA recipients into a path toward citizenship. What are you hearing? What are you aware of that might be coming up in the fall? Or is there any push, any organization that's happening? I've put out the feelers. I haven't heard too much myself. Are you hearing anything, Julian or Jaime?
Yeah, I mean, I think at least here in Illinois, the Illinois Coalition for Immigrant and Refugee Rights, they are, when it comes to the local organizing, the local base building and advocacy work, they tend to be kind of the clearinghouse for a lot of that. They have, I don't know how many, dozens, 60 plus, probably even 100 members, across the state of Illinois that are reaching out to different members of Congress. I know that they also have a lot of connections with national organizations that are solely based in Washington, D.C. that again work on the Hill. Some other staff members, interact with my director of policy, particularly who's based in D.C. as well, to kind of get a sense. But really right now, I think my understanding is the biggest push is what can be done via the, as I mentioned earlier, this reconciliation process, because, right now, in the Senate, you need 60 votes to pass anything. And there's just doesn't really seem to be an opening for any possible way to get to 60 votes in the Senate on any of these bills that were just mentioned without negotiating a lot, likely way too much away. And again, that's why I think people are trying to figure out what can be done through this reconciliation process to get to the point where you would only need 51 votes. And even then, that would still be kind of a hard thing to achieve, given that, as we've seen, the Democrat caucus in DC is there's fissures. They're not all on the same page when it comes to a lot of these issues, and so which you wouldn't expect in a political caucus of any sort. I'm sure the same thing applies on the Republican side. But that's what I've heard a lot of, is what can be done on that front, because it just doesn't seem like a path to 60 for anything that Democrats would want, at least is viable at this point, or has been viable. And so it's sort of a funky, it's a funky situation that really in the end just leaves impacted community members, right, continue to be impacted community members in overwhelmingly negative ways, unfortunately.
So I guess then a follow-up question to that, will this then become a, a status, for example, with people with DACA that will have to continuously reapply or renew, better said?
I mean, as long as the program remains intact, then yes, I mean, I think I think that would be the case. And I think that's been, I know I've seen a lot of people say, well, and I think justifiably so, right? I mean, was DACA always intended to just be this thing that you continually renew, and then therefore you have a set of people in this country that are here and are recognized by the government as being here, but don't have any legal status, right? They're just sort of in this limbo, constant 2-year limbo, right? Can they keep it up? Can they keep up? $495 likely will not. I mean, I know the Trump administration tried to increase the cost significantly for DACA renewals as a way to kind of weed people out, because $495 every 2 years, can be a cost that's too high for people to afford in that moment, and then therefore I've met individuals who went through that, who maybe had it initially had DACA for a period of time, but then when the 2-year period was ready to be renewed, were without a job, something was going on and could not afford $495, and then therefore they were out of status, and so Jaime can speak a lot better to kind of then what happens then, but it's a really difficult situation, so no one wants to just have people renewing every 2 years indefinitely, and still not enjoy the rights, that all of us who don't have to worry about these issues and too often take for granted.
It really is terrible. And I just had a client who I was working on his DACA renewal, and he was telling me, Jaime, this is like a membership. He was like, this is like renewing a Sam's Club membership, although every 2 years. And that's terrible because, so hopefully proposed legislation does lead to a possible pathway to citizenship, because that it's important to think critically. And I think you were on point, Julian, where was this the intention, and it's a money grabber, and that it's $495 at the moment. Again, as you mentioned, that can be a challenge for some folks. Other thing I'll note is that there are a good amount of different forms of relief, different applications in which there is a fee waiver, but DACA is not one of those, even though there are a lot of people who, struggle with that amount, and that nothing guarantees that the amount will continue to remain at that price, because over the years, it's just normal that things unfortunately go up. So hopefully something good comes out of this, and there's been a lot of advocacy and a lot of people who have been, trying to get these changes that have been overdue, in my opinion, and much needed.
Okay, thank you, Jaime. Another question here. Julian mentioned the risk of that phase out of adult immigrant detention in Illinois could lead to immigrants being detained out of state. How big a risk do you see that happening? And let me see. Okay, and then we'll move on to the next question.
I think right now, as it's, I think it's a big risk, because it would be the easiest thing. And the fact of the matter is, this is one of the biggest, this perhaps is the largest reason why this coalition of groups that we were, NIJC, were so fortunate to be a part of, that ICER was the lead sort of organizing entity for on this bill that passed both chambers, is we think that they'll just, what we know is that counties really can rely on these sorts of contracts to hold people, because they can be quite lucrative contracts with ICE, and it becomes a way to generate revenue for counties, and often is used as one of the biggest reasons why a county should enter into such an agreement with ICE is because one, usually the law and order piece, right, will get thrown in. I know in McHenry County, we heard a lot of that when McHenry County a few weeks ago was debating a resolution to end their contract on their own terms, which failed. They talked about, well, these people are a threat to our community. The sorts of usual talking points from people who don't see the value and the inherent human dignity of immigrants at large, unfortunately. But also usually right behind that is the revenue piece that a lot of individuals, private and also elected officials will mention, which is that, we're getting X amount of money based on this contract and it generates X amount in revenue, and it doesn't just go to the jails, but it goes to the general revenue fund sometimes for different counties. And, it's a gross incentive. It's a pretty hideous incentive to enter into such an agreement when you just see a dollar sign on someone. And it can lead to what, these unintended, I forget what the term is, but essentially, lead to, certain counties across the country, really taking a hard stance on immigrants as a way to kind of drive up local, essentially the body count in the jail. We don't want to see that here in Illinois. So our fear, there was already some word coming out of Clay County in Indiana is that Clay County has a contract with ICE to detain immigrants, and they had put out, word had gotten out shortly after our bill here in Illinois passed, that they were looking to expand their detainee population. And so that timing, of Illinois Way Forward passing here on May 31st, and I believe, June 10th or something, Clay County announcing that they were looking to expand their immigrant detention population seemed a little too coincidental, and so we're trying to figure out, was that a coincidence? Could have been, or was it not, given what they understand about what's happening in Illinois. So we think it's a risk, and again, it's just the easiest thing for folks that are already in that mindset. Well, this person was detained in Pulaski County, so if Pulaski County is no longer allowed to do so, then it should be detained somewhere else. And our argument, meaning all of us, as part of this coalition, is these individuals should have, should go home and be able to adjudicate, run their immigration case from home and work with hopefully their legal representation to do so without being detained, in a jail, and certainly not during a pandemic. And so, we think it's a risk. It's far too great of a risk for us to stomach at this point. So we're just trying to figure out, and working right now with Indiana-based colleagues in particular to figure out what's going on in Clay County, and then what can we do from where we sit here in Illinois to check in with these counties, 3 counties here in Illinois, and with perhaps even the ICE field office here in Chicago to work something out so that people don't have to be transferred but can go home, and have their cases adjudicated while they're at home and in their communities, which is the ideal situation.
Okay, another question. Any crystal ball on what might be negotiated from the varieties of proposed legislation at the federal level? I think you touched on some of that, but if you could just expand some of that thinking.
Yeah, I mean, I if I did, I hope I didn't touch on it too much. Honestly, I don't know. I mean, I think it might be still a little too early, and I'm certainly too far physically removed from DC to give you, a rundown of these bills. I think just historically, my understanding is that, often what becomes the pushback are issues regarding people that are that have a criminal record, right? Again, just people that may have had some sort of criminal record either 30 years ago or last week. And that often is a point of contention, right? Not just in terms of how long ago someone's had a run-in with the criminal justice system, but then what kind of crime was it, right? Was it a felony? Was it a misdemeanor? How many misdemeanors, right? All that stuff, I think historically has tended to be negotiated on both sides. And we hope that this year, those that are sponsoring the bill, are going to see that, this issue of criminalization in communities of color, immigrant communities, is very real. I think we're having that national discussion in a way now that perhaps we haven't had it ever. And I think that hopefully that will not be something that gets that Democrats in particular feel like they have to negotiate on and can take a harder stance on. But again, these are political realities that, especially if you have to have 60 votes, they may feel they have to negotiate something more, and sort of broaden the scope of who is allowed under these sorts of provisions. But then also, like, Jaime had mentioned, even just something like, well, we need to increase the fees for certain, immigrant related visas, for visas, let's say, or something that again seems relatively benign, but that has a really negative impact on immigrant communities, and often is kind of gets overlooked because it's not as showy as some of this other stuff, not as headline grabby, right? But that really has negative impacts. And so, I can't give you that's a very vague answer because I don't fully know, but I think historically that's sort of the thing that tends to get negotiated, unfortunately.
Well, thanks for that. This one goes back to, there's a couple questions more related to Illinois Way Forward. I have a question, like, how do we know these, they may not enter into contracts with ICE, but how do we know these local cops, will not be working with ICE? Or, I mean, they'll deputize themselves, can't they? I mean, is there any mechanism, or do you know of any mechanism that's gonna provide a kind of a watchdog for that?
Yeah, in fact, that's a part of the bill that was worked on a lot, which is accountability measures, because in 2017, the Illinois Trust Act was signed into law, and that bill was initially intended or viewed to be the one that would sort of decouple local local law enforcement agencies and officers here in Illinois, decouple them from ICE, right, and immigration enforcement actions. And it really, for those of us who, organizationally at least, that provide legal service representation, what we've seen is just case after case of that not being the case, which is to say that, once someone is detained and a lawyer representative goes to speak to them, they say, well, I was asked, where I'm from, right? Or I was asked about my status explicitly, things that were in the Trust Act, that local law enforcement could not do. That, if you're on some street somewhere, and you're stopped by local law enforcement, right, they are the law, right? It's that street level bureaucrat kind of power that, no one's necessarily watching over their shoulder. And so then they kind of go about doing those sorts of things. And so now what's in the bill allows the Illinois Attorney General's office to open investigations if there are accusations of such occurrences, right? If a local law enforcement official, clearly steps over the line and accuses someone of being undocumented, or explicitly asks someone if they are undocumented, right? Which now is not allowed to occur. And if that is brought to the attention, let's say, of an organization such as us, or again, like ICER or yourselves, you could raise that up with the Illinois Attorney General's office, and they could, if they so chose, given the available information, could pursue an investigation. And if found culpable of whatever occurred, local law enforcement agencies could be fined. There are other instances, there are other mechanisms, but that's the one thing that wasn't in the Trust Act from 2017, which we hoped to have included back then, but couldn't, again, because of some political realities that now is in this bill. And we are hopeful, that law enforcement agencies are going to really take that into mind. And there were discussions with law enforcement agencies during this period, during the negotiations or discussions regarding Illinois Way Forward, where this was not up for negotiation this time around. Like, we weren't going to negotiate that away. We wanted accountability measures, and they're in the bill now. And again, as Juan Carlos had mentioned earlier, we fully expect that the governor will sign the bill by the end of the summer at the latest.
Okay, we have I think time for one more question. We have 3 minutes left here. Alternatives to detention include ankle monitors, right? What are the pros and cons of this approach, including who pays for the monitoring, or any other alternatives to detention?
Yes. Ankle monitors are usually included. I think if you find any white paper or any other discussion online, of what are known as ATDs, alternatives to detention, that tends to be the biggest, that tends to be part of the equation. We are not interested in that. We, again, NIJC, but then also our coalition partners are not interested in supporting any sort of alternative to detention that includes ankle monitors. Our version of alternative to detention is be released, go back home, go to your home, to your community, to your family, and work with hopefully organizations like ours and other organizations that are empowered to represent immigrants through their immigration cases and have their cases adjudicated that way. So, the pros to an alternative to detention scheme that includes ankle monitors, my short answer is there are no pros. My longer answer is the only pro to that is that they are not physically in a jail cell somewhere. But that said, if you've ever met someone who has had an ankle monitor and spoken to them, you know that it is essentially like you still are in a jail cell. You very much are, and it's a horrible social stigma that again, members of the immigrant community, members of criminalized communities here in our country and in our community know all too well. And so for us, it's a non-starter as well when it comes to supporting something that will be pushed by anybody. And yeah, I guess those are the cons as well. Yeah.
Yes, it is. As we come to it's humiliating thing.
It's denigrating of someone's human dignity, to have to have one of those and still try to go about their lives, right? So again, I really appreciate. I think that if you had asked me, frankly, or other sort of larger organizations that work on these issues a decade ago about ankle monitors or as a part of alternatives to detention, I think you would have said, sure, we'll take it, because it doesn't mean that you're in jail, and we're not going to take that anymore. We don't want to see that. We don't want, when it comes to who pays for the monitoring, that's a good question. I honestly don't have enough of that information to give you a good answer, but I would love to follow up, Linda, because I think that often those are also for-profit entities that are trying to cash in on someone's sort of detention in another way. So
I would just add that to the comment of it being humiliating, both alternatives to detention, ankle monitors, as well as detention. I would call those human rights abuses. So, yeah, I think humiliating is keeping it politely, but of course also valid.
Yeah.
Thank you, Jaime. Thank you, Julian, for volunteering your time, your knowledge, your wisdom, your activism, and working with us. I thank you for taking time out of your busy schedules to make this happen.